When I saw my dear colleague Robert Jackson perform earlier this morning, I was reminded of a former student of mine, a Master of Law student who came from Austria, and he wanted to stay in the United States. He had just won the green card lottery, and he came to my office and said, nobody's really buying that he wants to become a litigator in the United States. So he was thinking about enrolling into acting school and whether I would write a reference for him. Which I did, and he enrolled, and then he of course got a job. But I never enrolled in acting school, so I won't do what Jack did for you this morning. Anyhow, so I have a paper here. I do have a paper. It wasn't posted on your website. It should be on your stick. I didn't post it because I'm using quite a few of the ideas that I'm developing in a book project, which I want to publish hopefully early next year or middle of next year. And so I didn't want to put it on an unprotected web page. So let me just try to walk you through the basic ideas here and link it to corporate law in particular. So I want to start with a little story that's a very familiar story for most of you. It's the story about Lehman Brothers. You have three brothers from Bavaria who migrate to the United States in the early 19th century, and they set up a little, they called it a grocery, but the term grocery at the time was used to suggest wholesale and commodities trading and some consumer goods. And then, of course, this is how it all starts, and it ends in 2008 with one of the largest bankruptcies in history. And here's sort of Emanuel Lehman. He was really most important probably for the formation in the 19th century. His elder brother who had migrated first died of yellow fever after he did some deals in New Orleans. And then you get basically the timeline here. Until 1924, it's really a family-only partnership. In the late 1920s, they do set up a corporate entity, but they remain a partnership. In 1965, LBI is set up as a broker-dealer. And then in 1984, the company is bought out by American Express. The real growth period of Lehman, I mean, it's already a very sort of well-known and very well-established firm, did very well for many years, but I think the staggering growth of Lehman really happens between 1994 and 2008. So when Lehman becomes independent again, it's spun off from American Express in 1994. As you can see here, it has 9,000 employees and about $70 million in earnings. In 2007, it has 28,000 employees, $4 billion in earnings. It has 22.5 billion in equity and hundreds of subsidiaries and even more special purpose vehicles around the globe. The structure is a highly simplified structure from their annual reports in 2007, just gives you a sense of how complex the structure has been. These are all incorporated entities. I don't even count other structures that they've been using. The little h they explain suggests that while they are set up as separate subsidiaries, they are guaranteed by the holding parent in the United States. So I just want to use the story to motivate an argument that suggests that the transformation of Lehman and so many other firms, both in the financial sector but also outside the financial sector, cannot be explained without understanding this as a legal transformative story. So Lehman employed the corporate law for shielding assets. That's the story, basically, that Henry and Rainier have told about 10 years ago, saying that one of the major functions of corporate law is to provide asset shielding. So we have asset shielding, and they do this also for minting fresh capital. So Lehman also, of course, benefited a lot from the rise of structured finance, which is basically the use of legal tools, trust law, credit law, property law, contract law, to mint fresh capital. But the point that I want to make here in this presentation today is that corporate law in and of itself also adds value to the process of minting capital, or can be used for minting capital, for example, by using sort of dividend payments from the subsidiaries to the parent, which then lends it back to the subsidiaries. That's sort of a transaction that is basically a legal game that seems to be adding value, but and sort of enhances wealth, at least in the short to medium term. Another one is, of course, legal and regulatory tax arbitrage. That's basically using the notion that subsidiaries are separate legal entities and employing conflict of law rules that you can simply choose different places of incorporation to set up hubs in different regimes, so you can benefit from regulatory differences and tax reforms, of course. And the point I want to make is that this is, of course, particularly pronounced, the exploitation of legal rules for creating value, minting capital in the financial sector, but it's not limited to it. Law itself, I want to say, is a key resource for minting capital. So when you say that, of course, you have to say something about what is capital and how do you define capital. And it's one of these ubiquitously used terms that is rarely defined. So if you go back into history, you find various definitions. Of course, it comes from the Latin word caput, which is the head. And in the 12th and 13th century, it was used to describe funds, goods, money, interests. By the 16th century, it was sort of more and more clear there was something that had already been accumulated, money of commercial entities in particular, but it could also denote, again, interest payments, some expectancies in the future. In France, it was defined as richesse, also something that has been accumulated that was of a stock of value. In the 18th and 19th century, it was more and more used in the term of being productive capital, and the distinction made between productive versus debt capital. In the paper, I suggest that Napoleon prided himself with the fact that France was using its own capital stock, its own wealth to wage wars, whereas other countries, of course, England, were mostly using their income rather than their real capital stock. So these are sort of different ways in which capital was used. And then, of course, then comes Karl Marx. And he defines capital as the means of production used to extract surplus from labor. So the notion that there's something extra that we have to extract from somebody else, which then, however, can also be used for further investments. And then contrast that with the very, of course, common usage of the term capital to simply suggest that it's one of the two major factors of production. We have labor and capital, and it's mostly an input to the production process. So if you spin this a little further, what I want to suggest is that since the early 19th century, we have shifted, or quite a few theorists, not everybody in their use of the term, but quite a few theorists have shifted in thinking about capital, not so much about something that you have accumulated in the past, although this is also true, but something that is an expectancy for the future. Marx already, I think, alludes to that by basically saying it's not only that we extract surplus from labor, but we can use the surplus to invest again and then do the same story one more time, right? So you extract and you reinvest, and then you have even more to invest and to extract and to reinvest. But still, he was still confined, I think, to a notion that is mostly about the accumulation of capital rather than thinking about how to create new capital in the future. And that changes a little bit with the American institutionalists, who are much forgotten, but I think really important in thinking about the evolution of the core institutions for capitalism. One of them, of course, is Veblen, who says capital is defined as the income yielding capacity of an asset. And then he says it includes land and government bonds, etc. Just, of course, in contrast to Marx, who would have said government bonds is not really neither land nor government bonds is capital because it's not human-made. So for him, everything that was capital had to be human-made. And Veblen sort of goes beyond that and says it's really about income yielding capacity of assets. And of course, that raises the question, where does that come from? John Commons, who has written about the legal institutions of capitalism quite extensively, being an economist, but really sort of digging into mostly US Supreme Court case law of the late 19th century to show the shift also in case law to a notion of capital that is future-oriented. He says capital is an exchange value of things. The expected additions are derived not from physical things, but from expected profitable transactions. Then Harvey, more in the Marxist tradition, says capital are property rights over some future revenue. And then, of course, we can't talk about capital these days without quoting Piketty. He also doesn't really devote much time to thinking about what is capital. He has a broad definition which says it's the sum total of non-human assets that can be owned and exchanged on some market. But it's also the exchange, of course, that alludes to something in the future. None of these authors, even though I think they make the right move in terms of thinking about the future, really say in what is it that makes an asset really generate future value? What is it that provides the income yielding capacity of an asset? What makes this really credible that we can do that? And here I want to come in and basically saying capital is coded in law. And we can't really understand the capacity of these assets unless we really dig into their particular legal structure. It's basically the capacity of an asset to generate future returns that are convertible into cash today. And that's particularly relevant, of course, for our age of financial capital. So what does law add to an asset? I'm basically, in the book, I'm making this very bold statement, and you can take me apart on that, but I'm making that statement basically saying, just give me anything. Give me an object, give me an idea, give me a claim, and I will flip it into a capital asset if I inject the right legal DNA into that particular asset. I have to code it in certain types of legal features, and we know these legal structures. We have used them for about 400 or 500 years repeatedly. Mostly their property rights, their collateral law, their trust law, their corporate law, and their bankruptcy law. These are the elements of the code with which you can flip any asset into a capital asset. So what does law provide? It provides priority over competing claims. So it creates hierarchies of claims that are universally enforceable, that have third-party effect. It creates durability, right? Some assets can stick together in a pool for long periods of time. Think about the corporation, it can be immortal. These assets can stay together for very long periods of time. And it can create convertibility by basically saying, yes, you can flip this thing into cash. Right? But also that sort of has to be legally structured. So that, of course, also implies that the state and state law are absolutely critical for the emergence of capitalism and the structure of capital, both domestically, and in the book I also have, of course, a long chapter on its global implication. And what I'm suggesting there is you can sustain a global capitalist system with a single domestic legal system, as long as all other states recognize and enforce the rights and privileges that one legal system has created. And I would argue that we're very close to such a system. We have two legal systems that dominate the world of capital. That is England, and now I really mean England and not the UK. It's the law of England and the law of New York State. Most of the capital that is traded globally is coded in one of these two legal systems, and that is possible because of conflict of law rules that ensure that these rights and privileges are recognized elsewhere. So, I already mentioned sort of the different elements. I don't want to say that property law, collateral law, trust, corporate, and bankruptcy law are the only ones. Contractual law, of course, plays an important role as well. It's ubiquitous, and you can give me many more examples of other legal tools, but I think these are the core kits. And the beauty of these tools, of course, is that there are institutions of private law. They're basically part of a toolkit that lawyers can use to cloak different types of assets into capital, to graft these legal privileges onto different asset classes. So how does corporate law come in? So this, just writing this paper for this conference gave me an opportunity to think about this more systematically. So the standard account, if we, those of us who teach corporate law, you go into the class and say, corporation, what is it? It has legal personhood, it has centralized management, there are tradable shares, and there's limited liability for shareholders. That's sort of the standard account that we typically talk about. But for capital, there's somewhat different properties that are more important than others. So I'm not saying this is wrong, but I'm saying for the minting of capital, other properties are more important. I'm building, of course, again, on the work of Henry and Rainier and others, that the asset shielding of corporate law is fundamental to this capital minting property that corporate law has, in the sense that you can shield the assets of the corporation from the personal creditors of the shareholders, right? So you throw a shield around a pool of asset that can stick together potentially forever, unless it goes bankrupt or is liquidated, but it's a high threshold. You need a supermajority requirement under virtually every legal system that I know of. So you have this asset shielding capacity, but you also have, and that sort of work that Enrico Perotti and Giuseppe Mattiacci and others have done recently, focusing on the capital lock-in. So shareholders commit capital, but the shareholders, even the shareholders themselves, cannot take the capital out of the corporation again. They can trade the shares, but that's a different thing. You commit, and this capital is locked in as part of the capital of the shareholder of the company company. So these are fundamental, and I'll say a little bit more about when they came about, for the capital minting capacity of a corporation. I already mentioned that once you make shares tradable, you basically have on one hand, you have the capital that the shareholders have committed, locked in, shielded from potential claims of their own creditors. But at the same time, the shareholders can still cash in the future value of this of the firm by trading them. And then I'm basically adding, saying, you know, corporate innovation didn't stop here. We have also more corporate innovation in this area over time. And two, in particular, I want to emphasize here. One is procreation, that is the ability of a corporation to set up other corporations. So the Lehman structure I just showed you wouldn't exist if you didn't have the power of corporations to set up other corporations. That also is not natural. They don't procreate naturally, but they must be given the power to do so. And then last but not least is the ability of companies to create their own currency. And of course, companies can issue shares. That's an old thing, but that you can also issue shares, sit on them, and use them as means of pay to acquire other stock is a more recent innovation in corporate law. So I'm just going to skip this in the interest of time. Others have done this before, just to show what is really specific about the corporation. You can contrast it with just different organizational forms. Here I'm basically going through the different elements and tell you when they came about. So entity shielding, this is again Henry's and Ranier's work. It's Renaissance Florence, where you get the partnership system, which has a little bit of that, and then the big trading companies of the 17th century. Capital lock-in is the Dutch East Indian Company is the first that does that, and it's basically imposed from top down that the shareholders cannot take out their shares even after 10 years. They are locked in for goods. Tradability comes along with that as well. Procreation really comes later. It is when first of all you have free incorporation, and that these corporations can set up their own entities in New Jersey in the 1880s, relatively late in the United States. So that's interesting. And then when I talk about corporate currency, I'm talking mostly about authorized but unissued stock and stock repurchase. That comes about in the UK and Delaware in the 20th century. So basically, I'm saying when you want to do shareholder value maximization, you can do two things. We talked a lot about the notion that companies invest in net present value projects. So you can either invest or you can boost shareholder value through legal engineering. And what I want to suggest is that this legal engineering has taken an ever more important role, and perhaps also perhaps the ability to do the legal engineering will also explain a little bit better why we see in some of the data that the law and finance literature has produced this advantage of the common law system. So I just dug out some old data I used in a paper 10 or 15 years ago, where I basically show that authorized and unissued stock comes in the UK, and I should have added Delaware here much earlier than in other. So this is mandatory, this is enabling law. And so the shift towards sort of this more capital minting type of legal structures happens much earlier in the common law jurisdictions than it does in the civil law jurisdictions. And that might, the real advantage of the common law jurisdictions might not be that they protect property rights better, as some of the literature has suggested, but that they give stakeholders in these corporations a much better ability, capacity to mint fresh capital. It's the expansion rather than just the allocation of existing rights. So how many minutes do I have left? Two, then let me just go. Let me just say a few words about where we are right now. So I want to just think about this in the current context. So what many people have shown and data suggests is that we live in a world of secular stagnation. So we see companies invest less and save more. This has been going on for quite some time. The question is how to interpret this, and I just want to think through whether it has any relation to what I've been talking about. So Eichengreen has put together this long chart by suggesting investment in the United States in the long term. He tells a more positive story, at least says it's plausible to think that we have periods of where investment goes down and then they are followed by sort of a spurt, and you see this here again, and so this might happen here again. So it might just be a harbinger for better periods. Larry Summers, who also talked about the secular stagnation issue, has suggested that many of these episodes that Eichengreen points out might actually be more closely related to bubbles. That would be probably more consistent with my story, because the bubble basically shows that the reliance on future expectations, which is what all this legal coding is all about, turns out to be wrong, so you get a much more harsh adjustment at some point in the future. So this is also data I just stole from somebody else, didn't put them together, but he again basically says this is sort of the investments. So this is profits going up and up and up in our period, but investments are relatively low in comparison to that. And then there's a series of work done empirically that actually suggests that we've seen a lot of use of legal steroids rather than actual value production through investments in the last 15 or 20 years or so. We have this major stock-for-stock merger wave, where Schleifer and Vishny already suggested in a 2003 theoretical paper that what might be happening here is that the acquirer are buying the assets of the target as a discount because they're using their own overvalued stock to acquire. There is some empirical evidence for that right now. Saver et al. Have actually shown that in stock-for-stock mergers, the acquirer benefits disproportionately from a successful merger. You don't see a similar effect in cash mergers, and the control for them was stock-for-stock mergers that had been attempted but failed. And another piece of evidence is repurchase programs. So we've seen a lot of repurchasing. Here are some numbers for the last 10 or 15 years where we see share repurchase and dividends actually being higher than investments that firms have undertaken. And a couple of papers have attempted to quantify what it costs for firms to engage in share repurchase programs. And they've shown that they do this at the expense of investments. So the number that they suggest there's about 10% R&D minus 3% and 5% labor shedding in order to have the cash on hand to engage in repurchase programs. Bonnet and others suggest that firms repurchase and mostly to smooth their financial statements. And if they didn't do this, and if you had a randomized repurchase, this would be less costly to the firms. So long story short, I should close here, perhaps maybe just the last picture, just to suggest one more piece of evidence is we have amongst non-financial corporations something that is increasingly recognized as a problem is that companies are sitting on huge cash pools, institutional cash pools, and it's not only in finance and non-financial companies. About $1.9 trillion estimated, probably a conservative estimate in 2010. It is held in bank deposits, only 3%. It's mostly held either in the shadow banking system, which is basically legally coded assets. This is all basically legal constructs, and the balance in treasuries. So all that suggests to me that we are living in a world where we extend substantial legal subsidies for the creation of capital and this has always been the case, but I think the extent to which this is used to mint fresh capital has increased over time. There are threats to the stability of the system because of that. There's of course also the big concern of inequality, and my concern is that we're basically, and this is where I'm going to leave you here, is we have an increase in private wealth and capital as a function of legal protections ex ante and ex post backstopping, as we've seen in the crisis. It thrives it thrives on explicit and implicit social insurance that is provided through the legal systems and the ex post backstopping system. And I think that should be a concern to us all. Thank you.
Okay, thank you, Katharina. So now we have Professor Kong-Sik Kim from Seoul National University to discuss the paper.
I'd like to thank the organizers for giving me this wonderful opportunity to discuss the paper by Katharina Pistor, a longtime friend of mine. And also I'm particularly grateful to the organizers to give me the paper without statistical formulas. And I have a confession to make. Somehow I thought that the time given for me is about 7 or 8 minutes. And yesterday I learned that I will be given 20 minutes. I mean, I brought only about 10 slides, and I just agonized, and Mr. Devlin kindly advised me to, why don't you read slowly? But maybe Mr. Becht would not like that idea, so I'd do my best to finish early so that you can have more time for discussion. Well, purpose of the paper is to explore the role of corporate law in the minting of capital. And the structure is, the paper is composed of 5 parts. I'd like to devote myself to these 2 sections, the meaning of capital and modern corporation. It's dealing with the role of corporate law. And according to her, she used various definitions of capital. According to her, the capacity of an asset to credibly generate income in the future and to convert these expected income streams into cash today. So the capital is not just an asset, it's capacity. But later, not later, in the beginning, her abstract, she used another definition, assets that have income yielding capacity with the added on that the expected future income can be realized today. And so it seems that her definition is composed of 2 elements, income generating assets and convertible to cash. And so what is capital? So this, income producing assets are not the capital. And then these securities issued by the corporation are not capital. And then maybe this combination of these 2, I'm not really clear about this, the meaning of the capital. And she says that the attributes of capital assets are priority, universality, and durability. And I think these are the conventional attributes of property, right? And she further requires that transferability. And if you add transferability, then it closely approach shares and bonds. And this conjecture of mine seems supported by the following statement of her. So the capitalists can mint their own capital by creating expectations about the future returns and generating current income from them. So maybe you can, just change this capital with this securities. Then, you can understand. But, on page 10, she says, in sum, the capital is not a thing, but a quality that is coded in law. So I'm just a little bit confused at this point. And then, just after this sentence, she says, a simple object, claim, or idea can be turned into a capital asset by grafting the legal attributes of priority, blah, 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 right? So I don't know exactly what she means, by this capital thing, or just capacity, or just quality. It's just a bit confusing. I mean, I'm a conventional law professor in a civil law jurisdiction, so that may be the reason why I can't really understand, clearly understand this use of the word capital. And capitals, let's move to this role of corporate law. And capital's attributes of priority and universality and durability are supported by corporate law. And regarding this tradability, she says, shares were, however, eventually recognized as personal property in their own right, and they could be traded by exchanging paper for cash. And the economic importance of trading the future income stream from corporations. When I reach this point, well, then it's if you just change this income generating assets like this, then it's becomes similar to a securitization. I don't know. I mean, she uses this in asset securitization in her paper. So what she means by capital is she's referring to this this kind of asset securitization. I know that there are some views about, critical views about this securitization after this global financial crisis, but I am generally in favor of the use of this securitization. I think that has contributed to the development of financial market, but that's not a big idea, right? And let's go back to the role of corporate law. Regarding the role of corporate law, she says two areas of change are particularly relevant for the minting of capital. The first is the rules governing the company's capital structure, broadly defined, and second, the right of corporations to procreate. Well, so the changes in rules regarding capital structure, she enumerates par value and the dividends authorized but unissued shares. I think these items are somewhat related to the minting of capital. But I don't quite understand why this repurchase of shares is related to the minting capital. Not particularly clear. And she says that the kind of increased use of share repurchase is an interesting pattern which perfectly fits the argument advanced in this paper that corporations are in the business of minting capital. I can't really understand, whether this is correct. Maybe I need more clarification. And let's move to these changes in rules regarding corporate procreation. She enumerates a separation of business risk and tax havens and pyramidal schemes. I agree that these items are related to this minting of capital. And she says that corporate law rules that allow corporations to beget other corporations and freely choose their residence are a powerful engine in the process of minting capital. Well, now that I heard her presentation, I can understand why this corporation's ability to beget other corporations is related to minting of capital. But I think it's more related to the entrepreneur's freedom to organize her economic activity. And let's discuss this role of corporate law from a different perspective. As you all know, that the law and finance people, focused on this role of corporate law in protecting investor rights, which led to the development of financial market. That's their argument. And she, has a slightly different idea. And she says legal systems that are more likely to vindicate the rights that private actors seek and create than others are the driver behind the minting of capital and financial market development. This is a bit abstract, so I have a hard time, just really understanding this. Maybe she's focusing on entrepreneurs rather than investors. Just the law and finance people just focused on this, the protection of investors, but in her case, she is interested in, just facilitating the activities of the entrepreneurs. Well, then maybe we can paraphrase that the flexible rules of common law countries like U.S., allowing the firm to issue and repurchase its shares smoothly without much cost, are a factor contributing to financial market development. If this is what Katarini is getting at, that I have absolutely no objection. And final remark. So this paper is full of highly interesting but not necessarily well known, and especially in some parts of the world. Pieces, I mean, I learned a lot. I mean, this is not a diplomatic remark. I mean, I really learned a lot. And I agree with most of her arguments, but I'm not quite sure whether I understand her main concept, minting capital properly. So I sincerely hope she will put more efforts into clarifying the concept of capital so that less sophisticated people like me can fully understand her valuable attempt. Thank you very much.
Okay, so thank you, Professor Kim. So, well, maybe Katarina, you might wish to respond to his questions first, and we can collect questions later on.
So, oops, be careful. There you go. So, what I'm asking my commentators and, of course, my readers to do is to rethink issues from a different perspective. And the burden is on me to make clear how I want people to rethink these issues. So you can, of course, tell the entire story about the corporate law and its evolution in terms of greater efficiency, more financial market development, growth and development, and all the good things as well. What I want to suggest is that law as an abstract institution can become a value in and of itself to create private wealth, which I use, as Piketty does and others do, as synonymously with capital. And what I try to show is how this is being done. So yes, you can tell the story that the standard law and finance theory literature does, is that flexible rules and private parties doing all kinds of things help grow financial markets. But at the same time, you can also show is that people who have access to the coding of capital can increase their wealth disproportionately, and this is not necessarily welfare enhancing. Maybe everything people do is always sort of enlarging the pie is great, but if it enhances instability at the same time, it's not so great. Let me just come back to the notion of capital. Any object, asset, something, any idea I'm arguing can be flipped into a capital asset with the right legal coding. So give me an idea, right? An idea as such is not a capital asset. You have to create something like a patent right. You have to create property rights around it. So yes, priority, universality are core attributes of property. Durability, not necessarily, because your assets can land on the auction block in bankruptcy proceedings. But by throwing them into a trust or into a corporate law, you make them even more durable. So you have different legal devices that you can use to enhance the capital attribute of different types of assets. Yes, it is essentially, if you want to reduce it to one particular institution that is absolutely core, it's of course property. But it's not property as if it always existed. We shouldn't reify the notion of property rights. We're creating property rights all the time. That's what the financial sector does. Every financial asset that you're creating, you're throwing a couple of assets into a pool. They're issuing tradable assets to others. If we recognize them as tradable, as assets, and that's all you can show this, that courts and legislators have given these kind of credentials to these assets over time. That's when they become capital. That's when you have a credible commitment that you can cash in future cash flows today. So let me just leave it at that and get more questions so I get a sense where people are.
Okay, so Amir first.
So even in this short presentation, you made a clear effort to distinguish between assets and property and capital. So my sense is that the capital that's more interesting for you is clearly not, land, livestock, and stuff like that, but the corporate kind of capital. And here, I would urge you. I mean, what was missing for me, and I would urge you to explore, is the human factor. I mean, people are missing from your account. And perhaps what's crucial in explaining and developing these ideas, and perhaps what Consik was missing too, is the role of people in this development. So the idea is that in a corporate form, you have to have people inside the asset, whereas with regard to land, livestock, and so on, people are outside, obviously, of these assets. So this is something that I think might contribute to a better development of these ideas.
Let me just say a word about land. I talk a lot about land in my book as well, because land was the most important capital asset until the end of the 19th century. So Piketty has very interesting data on this and talks about the metamorphosis of capital. So when you look at what are the wealth-producing assets over time, it's rural land, mostly in most economies until the end of the 19th century, and then it becomes something else. It becomes shares and bonds and financial assets, and if at all land, then it's urban housing. But the rural land as a capital asset is not just a piece of dirt. It's enclosed land that is a property right that can be used as a collateral. And in England, it was protected as a wealth retaining, not so much producing over time asset. It's a wealth retaining asset because you could not seize all land that was owned by families until the very end of the 19th century. So used basically protection from bankruptcy law in order to retain the private wealth of families in England until 1881. So again, even for something as simple as for land, you need the legal protection to have it as a wealth-producing, wealth-protecting asset. It's the same thing. It's the same type of institutions that you used for land that we're now using for financial assets. That's core to the story. So where do the people come in? The people come in, for me, for my story, mostly as sort of who are the clients and who are the masters of the code. The masters of the code are the lawyers, and the clients are the best paying clients who have access to the lawyers to make sure that this capital is coded. They have to be smart. They bring some skills. I don't want to deny that. They also produce some goods, right? But in the coding of capital, as I define it, the key is control over the code and access to the code.
Okay, Henry then.
Yes, is there a microphone? Thank you. You began your talk with an interesting survey of the life history of Lehman Brothers. And you pointed out that after it incorporated in 1984, which was very late actually among investment firms, it created this elaborate structure, this labyrinth of subsidiaries, and all in exponential speed. And two related questions. One is, why did they do that? I thought I heard you say that the parent guaranteed all the subsidiaries. So they threw away limited liability. And so what were they trying to do with these subsidiaries? What was the point of having them out there? And what is the moral tale here? Is there is the capacity to create subsidiaries a destructive capacity? Were they misusing subsidiaries? Was this a temptation that capitalism leads us into? What is the moral of the story?
Yeah, I think that, on the moral point, it's of course the temptation. So I think it goes back to the paper we just had earlier about bankruptcy. How much protection do you give to debtor? And I think there's probably not an optimal line, but I think we all would agree that there is some threshold where you have too much debtor protection, where you take the system for a ride. You just abuse creditors too much, or you create a too unstable system. And I think similarly here, I'm not saying that procreation is a bad thing. But it's not surprising that in the 19th century it took big battles in the United States to think about whether corporations could set up other corporations, because it's not really clear where this is going to lead. And different companies have uses to different ends, but I think we have seen a lot of use of subsidiarization to, you can say, diversify risk, or shift the risk, externalize the risk of our undertakings toward creditors and others. You've written about this, many others have done the same, right? What about Lehman, right? I think Lehman have used procreation for tax arbitrage, regulatory arbitrage, and risk diversification. For almost every new instrument that they wanted to create, they set up a different subsidiary. They use different subsidiaries to get around regulation. So the London subsidiary of Lehman was subject to capital adequacy rules under the EU, so they set up another subsidiary under Swiss law that was closely linked, operated out of the same offices, had the same staffing as the people in the London subsidiary, but they could basically, through repo arrangements, make sure that all of the liabilities were on the Swiss entity, which was not subject to these regulations. So that on a grand scale is I think, how they...
Consolidated in bankruptcy, or were they
No, they were not consolidated in bankruptcy. They were all separate bankruptcy, and the receivers in bankruptcy all fought each other for years, which is why the bankruptcy became so complex and expensive.
Okay, so Gerald.
Thank you. Katarina, if I understand correctly, your presentation from a functional perspective, what you're talking about actually is asset packaging. And you can package them in corporations, in trusts, in mutual funds, in various vehicles. And I would encourage you to try to take that approach, though. What are the differences in packaging, which is the law, by the way, and what are the efficiency and other implications? Was the way you do your presentation, you focus exclusively on corporate law, which is a bit less exciting, I guess.
Fine, I'll take that. I thought I would write about corporate law for a sort of symposium on corporate governance. The book deals mostly with credit and trust and collateral law, and so it is about asset packaging. It's asset packaging in law, and the contribution that law makes to the asset packaging and the ability for those who have access to the particular packaging that we want to use to create private wealth, and how the legal system basically subsidizes that. That's what the core is all about. And the corporation's role, I think its most important role would be the shielding, but I think it can also be used for minting in its own capital, minting in its own right.
Okay, so I have Alexander and Host and Jeff in my queue. So yeah, well, okay, you can come to this and we'll go back to you later on. So maybe Host. You're fine? Oh.
Thank you, Katarina. You are concerned mostly with property rights, legal code of capital. Access to the code of capital gives you access to appropriate wealth. In a broader sense, this implies that a ground thesis of law matters, in a sense, and the access to law, the legal code, matters a lot. So I'm wondering why you're leaving out a contract in the equation. Arguably, freedom of contract and the extent to which you can write contracts is more important if you're talking about legal code and the possibility to appropriate wealth than maybe the ability to turn something into a capital asset as you define it. And secondly, that ties into what Henry has said, I believe. I hear you developing a descriptive social scientific story. You've got access to the legal code of capital, you've got access to the possibility of appropriate wealth. Now, is there a normative dimension to what you're doing as well? What are the consequences, in this case, for corporate law? Or is that something that you're not interested in at all?
Oh yes, I am interested in that. So on the first point, why not contract? Contract is in it as well, but I focus on these other institutions mostly because these are institutions that are or used to be much closer under the rubric of state determination of what the boundaries of property rights, for example, are. It used to be the case that property right would be defined by the country that has jurisdiction over a particular territory where the property is located. That's, of course, out of the window once we have assets that don't have a location. So I think it's the contractualization of legal institutions that were much more under the prerogative of a state, or let's say a legislature or democratic self-governance in determining who has the right to use what kind of things. So, the enabling corporate law, the free choice of law, where I want to incorporate, this is basically the contractualization of institutions that are much more central in the creating of hierarchy and making sure that the state enforces these particular rights. But it's if you want to, everything's becoming contract, to say it more extreme. So I'm not leaving contract out. I'm basically saying institutions that used to be not on the contractual side have become contractualized, and that's part of the story. The normative side, I think one of the normative sides is sort of to think more about, for example, shareholder value maximization. What does that mean if much of, or a considerable part of the shareholder value maximization comes through legal steroids, essentially? That also have not only benefits, but might have the downside of increasing instability. So that is a fundamental concern. So where are the boundaries of how much leeway do you want to give private parties? Should we really lean back and say the markets know best what's good for them, or the shareholders know best what's good for them, if the shareholders have, of course, the temptation to make sure that their returns are the highest? And that's, of course, how we use repurchasing right? So the company uses its cash rather than using it for reinvestment. It uses its cash to smooth its financial statements, to make its investors happy and keep investors coming. So that gives it sort of a firmer base. And you can tell the other story as well, that it's maybe an efficiency-enhancing instrument. I'm just sort of suggesting it's just look at it from a different side. It's just not only that; it has a certain bias in its use as well.
Okay, so Alexander in the back.
Hi, thanks. So this may be the economist, not quite catching up to what you're looking at here, but I was missing a little bit the connection to the Modigliani-Miller theorem. Are you thinking of law as a friction which allows us to create value through packaging? Or are you thinking of law as the solution to pre-existing frictions, which allows us, therefore, to create value? I mean, sort of the benchmark of the value of an asset being determined only by cash flows, would that be a useful framework to cast your discussion?
I think if I have to choose between the two variants, I probably would choose the first. It's about the packaging and thereby the creating of value and in its own right. And for me, the key question is then sort of who makes these kind of decisions about what kind of assets and what form of packaging can create value. I'm not sure if this fits. I don't really see the connection to the Modigliani-Miller theorem the way you put the question, but.
It seems like we have to talk more over coffee, because
that
seems to me the centerpiece of understanding where capital or asset value is created. But that's the economist's view.
Yeah, but the problem, of course, is that they abstract from everything that I'm talking about, right?
Okay.
Yes.
Yeah.
Okay, so now Jeff.
So I want to come back to the Henry question about what the moral is in the tail. So is it that through that law is a technology that has created a form, an organizational form, the size of which, the scope of which, creates a democracy deficit? I mean, is that the sort of the hidden or the implicit story here is that the scale of the firm has outgrown, in effect, the governance capacity of the societies within which these firms do business or proceed, and law has become the technology by which the organizational forms have outstripped the democratic means of governance to set the ultimate objective function for the society as a whole. And so you're seeing law as a technology that has undercut democratic capacity.
Yeah, I think that's not wrong. I just want to add to that, the institutions I'm talking about, they go back to feudalism, right? So I don't want to make a claim that at one point there was a rosy picture and everything was democratically determined, and then at some point this outstripped our capacity and that's the end of it. I think there's always been this tension between having institutions of private law that were vindicated, mostly exposed by state courts or legislatures, and thereby made universally enforceable on the one hand, and then if you just vindicate institutions of private law that are malleable in the hands of lawyers, you give them a lot of power in coding these type of assets. And that's welfare enhancing, and I want to deny that. But I think there's a threshold effect as well, in particular when we talk then about democratic self-governance. And I think there, your story resonates, and in particular when you think about the global impact of that. So if I can incorporate my entities wherever I want, if by incorporation I can determine the jurisdiction that says what the law is that applies to the property rights, to the asset that entity is issuing. I can do this mostly in 2 jurisdictions around the globe, and yet the assets can float around. Then we have a fundamental, I think, democratic deficit. And it's, I think, exacerbated by the fact that it's a hugely biased type of world that we live in, because you have to have access to the coding of capital in order to benefit from the economic benefits that this brings, which is wealth creation, right? So if you put this all together, if you think about our institutional cash pools and the uncertainty that this brings, if you think about the question that we have, the wealth discrepancies, I think this is has a lot to do with the ability of some to have access to the coding of capital and others not, and we have no control. We have no control over this anymore because we've given most of it away. Not only that these were always private institutions, but through conflict of law rules and choice of law on a contractual basis, we have lost political control over these institutions.
Okay, so Merit and then Giovanna and Roberta. So maybe last 3 questions.
Thanks. I guess I want to pursue the normative question because I think the more you could talk about that, the more I think a lot of us can understand the points that you're trying to get at. So, I mean, I'm a little confused, for example, when you said, well, maybe this is relevant about share value maximization. What does that have to do with minting capital? Why would you need all this structure to come up with a critique of share value maximization? Well, I'll leave it at that, except there was I was struck by one other thing you said, which is it seemed like you were critical both of corporations sitting on mountains of cash and using cash to repurchase shares. And those seem like contradictory concepts because repurchase of shares is it's just like paying dividends. I mean, it's just getting cash out of the corporation and into the hands of investors who will either consume or invest it in something else.
Yes. So on the first point, I don't need the entire framework to do a critique of shareholder value maximization. It's just an additional thing that you can do with that, but that's not the point. I mean, there are other ways to critique this. Many others have done that, so we don't have to go too much down that road. But the only point I want to make is, if we measure shareholder value by looking at share prices over time, I want to say that part of these share prices can be gained by using sophisticated legal techniques and has nothing to do with fundamental value. So I'm not a great believer in fundamental value to begin with, but when you think about this, then there's even less to be said about that. So that's the one point I would say. I also don't want to sort of spend too much time thinking about, is it good for a company to have cash or not cash under different circumstances? It depends, right? This is Robert's answer for everything. It always depends. But what I would like to suggest is that, for example, on the repurchase, if the evidence suggests that it's not being used as a substitute for dividends just to give cash into the hands of the shareholders, but it's systematically used to smooth income at the expense of investments, R&D, and labor, then that's a different type of story. That creates value for a particular group of stakeholders at the expense of others, and it's actually not producing future investments in real terms.
So 2 final questions from Giovanna and Roberta. Then, so can we correct both questions first, and then you can respond all together?
Let me see if I understand your point. Your point is that there is financial innovation through access to this legal code, and that the innovators appropriate the wealth from innovation. You call financial innovation minting capital, and you have this idea that the minting of capital is possible through this access to the legal code. Now, there is another leap, which is the implications for wealth distributions and for overall social welfare. And I think that the 2 aspects are who has the access to the legal code and how large are the barriers to entry? Because if there were no barriers to entry, so that needs a lot of evidence, which I think is available, whether, so the barrier to entry. And then the last slide was pointing to that this financial innovation is actually welfare inefficient because it crowds out real investment. And now that is more complicated to show that the return to this alternative investment that is being crowded out would be indeed higher. Mm-hmm. So I think that is...
Yeah, no, but I think you got my basic points, and I obviously this is a question is about entry barriers to the legal profession and entry barriers to the lawyers relative to what they can do with the law, how flexible the law is in the hands of lawyers. I think both goes, and I also take the point that when we think about the relative value that you get out of that, you have to think about what is the alternative and how is that created. How to quantify that, I'm not entirely sure. I'm basically just looking at illustrative evidence that something is happening that is not generated from investment, because we know that investment rates have been going down. It's generated by something else. And the discussion about what to do with the stuff, the cash pools that are sitting on the balance sheets of these corporations is giving headaches to central banks around the globe, because that can just blow up your financial system again. So when people are then discussing about whether the central banks should put up some facilities to buy this stuff, that's when I'm really getting concerned, because then we're underwriting in an insurance type of fashion the assets that have been created in devices that were from the get-go not necessarily social welfare enhancing. But yes, there's data limitations here. I agree with that. Sorry, I should have gotten Roberta on board first. Why?
Okay, so Roberta.
Roberta.
Thank you. So going back to the picture of Lehman, there are two things that one could be concerned about. One, or at least that you're discussing, size or transparency. So one question would be, could they be as big, or if they, would it be as problematic if they were as big but they didn't have 500 subsidiaries, if they could do that? Or if they were fully disclosed and we saw all of these SIVs, or we understood how that affected the value, would that be an issue? I guess it's trying to get at what you're concerned about with the use of financial innovation. Right, to understand that, because one could say with size, we have other mechanisms, antitrust or public law, that could operate here. Even on disclosure, I guess we could use that system to understand. So one question is, so why doesn't the public system then, depending on which you think is the problem or both, is there an issue about why the public law can't address that issue, or is this a capture story? The other sort of angle you might want to bring in is the financial innovation. Where do the gains from this come? So some must go to the intermediaries who suggest the corporations to use the financial innovation. And I don't know, the literature is debated, but there are these people who say, the financial sector is, it was bad that we have money in the financial sector, other people don't. I don't know if that's the literature that you want to connect with this. And I just add one thing about I didn't understand the last slide, because another reason why you've got all this built up has to do with regulatory uncertainty. Right, and you might want to bring that, and why corporations aren't spending the money, because even if you have low interest rates, if you're uncertain what's going to happen in the future, you might not want to invest it. I don't know how you want to bring that into your sort of discussion, because you're sort of saying there's certainty about corporation, right? But there's all sorts of different ways.
Yeah, let me just be brief. I think it's not size alone. That's not the point. I think it is sort of using these legal vehicles to engage in regulatory arbitrage, legal arbitrage kind of things, sort of, and to disguise the fact that, in fact, as Henry also suggested, there's a lot of guarantees and there are credit lines and all these things, but we're pretending that we have legally independent entities that engage in these things on their own risk and exploiting these different features for that I'm more concerned with. And I don't think you can get to the bottom of that simply by disclosure, because the investors are sitting really on the periphery of this entire entity. But we can talk more.
Okay, so unfortunately we had to stop here. Okay, well, thank you, Katarina, for interesting paper. Okay.